Okay. Welcome to the September 14th morning docket of the Kansas Court of Appeals. The case we are ready to hear right now is 120679 Richard Powell versus the state of Kansas. Would the parties state their appearances, please?
May it please the court, Meryl Carver-Almond on behalf of Mr. Powell.
May it please the court, Christopher Schneider, Assistant Wyandotte County District Attorney, appears on behalf of the state of Kansas.
Okay, Ms. Carver-Almond, did you wish any rebuttal time?
3 minutes, please, Judge.
3 minutes, okay. You both have been in front of us many times before. Just realize that we've read the briefs, we're familiar with the facts of the case, and so since you only have 15 minutes apiece, if you can get right to your argument, I think that would be beneficial for everyone. Joining me today on this case is Judge Stephen Hill, the longest serving judge in the state of Kansas right now. And also joining me is Judge Melissa Taylor Standridge, who is not the longest serving judge in Kansas, but's been on our court 13 or 14 years. So with that, Ms. Carver-Almond, you may proceed.
Thank you, Your Honor. May it please the court. This is a case about whether it's reasonable strategy to do nothing for your client when there is something that you can do for your client. My client was convicted of capital murder in 1999 and was spared the death penalty kind of by accident. A lot of procedural history happened between then and now, but the subject of this case is a second 1507 motion that he filed after his direct appeal and first 1507 motion were concluded, arguing that there was newly discovered evidence. One of the witnesses in his case, one of the witnesses that the state alleged was riding around with him on the night that these murders occurred, had recanted his statement. And so Mr. Powell, basically, as soon as he practically could, there was some, he had to wait for his federal appeal to be finished. He filed this new motion arguing that this was newly discovered evidence. And he was appointed an attorney to, go ahead, Judge Hill.
Yeah. Judge Hill? Yeah.
I do have a question. This is concerning 1507 counsel, correct?
Yes, sir.
Now, when we take a look at questions arising about the effectiveness of 1507 counsel, do we have to find that relief would have been granted but for the ineffectiveness of counsel? Is that the standard we must follow in this particular case? In other words, because this counsel was ineffective, this man would have gotten relief, habeas corpus relief in this case. Do we have to decide that way?
What you are looking at in this case, what we're arguing that you're looking at is whether the result of the proceeding would have been different. And I'm kind of arguing this two ways, because I'm arguing it under the chronic standard where we presume prejudice, and also under the Strickland standard. And I think either way we can win. Obviously the chronic standard is much easier for me. And under the chronic standard, the standard is that it's basically as if counsel wasn't there. And in this case, I think Mr. Powell might have been better off if counsel hadn't been there in a lot of ways. But under both tests, I think you have to start by looking at what counsel was supposed to be doing in order to evaluate how well they did those things.
Now, this man that had recanted his testimony, had made the affidavit recanting at least a portion of his testimony, was in custody in jail when this hearing was being held. Is that correct?
I believe that's correct.
And counsel, though, interviewed this witness and then told the court something I think very interesting, saying, you know, I don't want to call this witness and I'm not going to comment about what's in his affidavit because of ethical concerns. Now, how are we to take that? How are we as a court of appeals to view, I know how the district court reacted to it, how are we to take that in a record where the counsel's ethical concerns are raised, I think, directly to the court.
I think this case is largely on both issues controlled by State v. Smith, in that counsel has a role to be an advocate for her client and the district court is the fact finder. There were a lot of things that Kenton Williams said over the course of this case, and it's the fact finder's job to decide which of those are true and which of those are false. And I agree with the court. A lot of counsel's decisions are protected if you can say that they're strategy. And if she had had some kind of other option to go to, I think, very much we could say, well, it's not reasonable to call this witness who may get on the stand and say that whole affidavit was a lie. She didn't have anything else. There was nothing else that she chose to raise instead. And that's where we come to the choice of, she had the choice to do nothing or she had the choice to try something. I also think it's important as to the ethical concerns. If you read that hearing, my client is not urging her to lie to the court or be dishonest or hide the ball in any way. He says, I don't know what this guy is going to say. Let's put him on the stand. Let's figure out how he says I supposedly coerced him. Let's hear the evidence and see what he says. My client wasn't coming in and saying, let's have him lie. It's not a case like that. And in a case like that, I think. Go ahead.
How do we know that? How do we know that? Isn't when counsel said, I'm not going to argue anything about what's stated in this affidavit because of ethical concerns, isn't that a huge red flag to say, look, Judge, I think this man's lying and I don't want to suborn perjury in front of a court because I've got an ethical obligation to the tribunal. Isn't that what's going on here?
I think if you look at the ethical rules, counsel has to reasonably believe that a witness will be lying. And again, I think the problem is, when was he lying? Was he lying when he wrote the affidavit? Was he lying when he originally testified? And that's what the finder of fact is there to figure out. And it's not counsel's role to jump into that place.
But the district court,
Okay, I'm sorry.
The district court, when it heard this, focused on what counsel said about the affidavit, correct? All right. So there was some fact finding, it seems like to me, by the district court when it said, yeah, I see what's going on here. But anyway, go ahead. That's my big concern.
Okay, so I just want to see if I have the framework right here. It seems like on appeal you have two claims. The first one is the denial of the 1507 based on newly discovered evidence, and then also an ineffective assistance of 1507 counsel. So my first question, is that right or not?
I would disagree. So we're not asking the court to grant his 1507 motion at this time. What we want to happen today is I want this to go back for a new hearing. I want to get Mr. Powell some counsel that will really investigate this and really look at this. And I want to have a new 1507 hearing with effective counsel.
Okay, so you're not asking for, what, lack of a better word, for a Van Cleve hearing? Because it seems as if on the ineffective assistance of counsel that there are factual findings that need to be made about the effectiveness of counsel and whether or not her performance was deficient. So are you really asking for a Van Cleve?
And I struggled with that in writing this case, if I wanted to just straight up ask for a Van Cleve hearing or if we should remand it to just do the hearing over again. Ultimately, I think for purposes of just judicial economy, if you remand this back to do a Van Cleve hearing, somebody is going to have to necessarily investigate the full case and look at the full case. And if we're going to do that, we might as well just have a hearing on it. It seems like kind of a waste of time to have someone do all that work. If procedurally that is what the court felt was appropriate, of course, we would be fine with that.
On the issue of deficient performance, what if you're arguing deficient performance and saying that counsel didn't do anything, which you're citing to the Chronic case, what would you have had counsel to do?
I would have had counsel put Kenton Williams on the stand and ask him those questions. I would have also had her. I mean, frankly, there are a lot of issues in this case that I would have liked to argue on appeal, but because she didn't proffer anything about, how
about what
capital case was mishandled, about.
But she did try to do that, and the judge shut her down.
She didn't try that. I mean, okay.
There was a
then-
pretrial at the pretrial conference. The judge said the only issue here is going to be the affidavit, because she really made a strong argument. To me, at least, when I was reading the record, this guy really didn't get everything he needed in the capital case, brought up all the issues about his lawyer, about the judge, about the investigator, and the judge shut her down. So would you have had her bring that up even though the judge already said we're not going to consider that?
I guess I disagree with you that she made a good proffer. Now she brought up, I think she
It wasn't a proffer. It wasn't a proffer. It was at a pretrial conference, right?
No, and I know the part of the record that you're talking about. I guess I would say that that was not what she did. I did not feel like was sufficient. She kind of said this wasn't handled really the way that a capital case should be handled, and that was basically her comment on it. Whereas there was a lot of stuff, and it's frankly the kinds of things that I tried to get the court to take judicial notice of, and my motion was denied, and I respect that, but. Gosh, it sure would have been nice if I could have gotten that into this appeal in a more direct way. And because she didn't.
But that's not what you're appealing, right?
Well,
what you're appealing, I mean, your issue is, because the only issue that the court considered and I think the court denied the 1507 on the merits. I mean, pretty much on manifest injustice, when I read it, said, okay, you have an excuse for not raising it. And then the district court said we're required to grant a true trial only if satisfied that the recantation is true and material. We'll assume for purposes of this hearing it's true, and then went on to talk about how it wasn't material because Kenton wasn't present at the shooting. He wasn't an eyewitness. All his testimony was circumstantial. And then you had Marcus Henderson and Dante Jones, who also testified about the gun. And then you had Brandy, Myron, Vanessa, and Dante, where he expressly admitted that he did it to those four. So to me, the judge ruled on the merits. But you're saying that you're not appealing that, right? You're not appealing.
I'm not appealing that because we are purely arguing that his 1507 counsel was ineffective, because it's pretty easy to make a ruling on the merits when you haven't heard all the evidence. And that's part of it. You bring up all those witnesses that testified. There was inconsistent testimony about the timing of all these things that happened. There were witnesses that had motivation to lie in there. And some of that was apparent as the trial was going on, and I understand that. But a lot of that takes on a very new color when you consider what was going on with the Wyandotte County Police Department at that time, when you consider that the defense attorney in this case was under investigation for 7 ethical complaints.
Right, and I understand that, but I just want to make sure that I understand correctly that the judge prohibited 1507 counsel from arguing any of that, right? Said the hearing is only for this affidavit, correct?
He prohibited her from arguing that. I believe that her response to that, she basically said, okay, judge, that's what we'll do. Her response to that should have been, Your Honor, I understand your ruling. I'm objecting for purposes of appeal, and here is all the evidence that I would present if you let me make these arguments. And she most.
But that wasn't in his 1507 petition, right?
I think it is part and parcel of how you consider that new statement. You can't talk about whether it's material or not without looking at the broader circumstances.
Well, what he alleged in his petition is Kenton was the only one to provide evidence of guilt. And that's why he said it was material.
And I don't know what I can do with that, Your Honor. It was a pro se 1507 petition, so he was probably doing the best he can, and I would argue that we should interpret it more broadly than that.
Okay. Thank you for answering all my questions.
Thank you. I'm not sure how I'm doing on time. I have no sense of it, but if the court's okay, I would like to just briefly touch on the denial of Mr. Powell's motion for new counsel.
Yes, in fact, I was going to ask you about that, because he did at the time, he said, this attorney isn't doing what I'm asking her to do. I want a new attorney. This is a clear conflict. Is that what you're getting at?
Exactly, yes. And I think if you look at the Smith case, I think it's directly on point here. I think a different attorney could have done something different in this case. I think a different reasonable attorney could have done something different in this case. Again, it was a choice between doing something and doing nothing. And she decided to do nothing. And I think Mr. Powell was right to be dissatisfied with that. And I think the judge erred as a result. in appointing new counsel, or in refusing to appoint new counsel, I'm sorry. And it is an abuse of discretion standard of review, and I understand that, but so was Smith, and the Supreme Court reversed in that case. And I think this case is tracks almost exactly with Smith. And as a result, at minimum, we would ask this court to remand for a new hearing with new counsel in this case.
So maybe I'm conflating these issues a little bit, but under chronic, you're not required to show prejudice.
Correct.
Right. So if we find that her performance was no different than had he not had an attorney at all, then we've got chronic and don't have to, and there's prejudice doesn't come into effect. But if we don't have chronic, Judge Standridge mentions a good point. How do we get past the prejudice prong when the judge specifically found, okay, I'm going to assume that what he says in his affidavit is true. And I don't think that would have changed the results of the case. How do we get past that?
Well, I think that, again, and I hope I'm not just repeating myself, but I think there are two problems with that. And one is that it really puts the cart before the horse. You know, you haven't heard all the evidence. You didn't have this witness come in and look at this in the full context of the case. So, you know, if we're going to make,
but all he could testify to is what was in his affidavit, right? And his affidavit says I lied. And you know, I don't know if he was responsible for this or not. And the judge said, okay, I'm going to take that as true. You don't need to put him on. I'm going to assume that's all true. And he still doesn't win.
and
that seems like a really big hurdle in this case on if we reject the chronic analysis.
And that's probably more specifically to the ineffective assistance of counsel side,
Right.
I think, in the motion for new counsel side. The other thing is, I think if again, a lot of this evidence had been proffered and discussed below, then that would have made stronger arguments on appeal for me to argue that weren't really available to me.
I mean, the really good arguments, I mean, the things that you really want to get in, and apparently Ms. Erickson wanted to get in too, was the fact about the officer is, you know, credibility is shot. This was terrible corruption on the part of the Kansas City, Kansas Police Department, and his trial counsel's been disbarred too. And I mean, that's the stuff you wanted to get in. That's the stuff she tried to get in, although you're saying she didn't try hard enough. Although I think she said, I have experts that I want to bring in to testify to this. And the judge said no.
She didn't even mention the ethical complaints or that the attorney had been disbarred. In fact, that was something that I figured out, and it was actually shocked the heck out of my client. So right. Her statements, I'm really disagreeing with the court about her.
Okay, and I haven't gone back to read those as Judge Standridge has, but
yeah, I guess I would. I mean, the record will show what it will show, but I would urge the court to go back and specifically look at that because, you know, if we're talking about what she was trying to do or what, you know, I'm calling it a proffer sort of globally, she really did not bring in, you know, she just said this case really wasn't handled the way a capital case should be handled. And that was basically the end of her statements. She didn't talk about the fact that there was only one attorney on the case. She didn't talk about the fact that he was, you know, they had an intellectually disabled client and nobody apparently realized that because they hadn't looked at his educational records. I mean, even in 1999, this is bad. And she didn't really talk about any of that other than in one or two summary sentences. And then the judge said no, and she said, okay. She didn't talk about the police department at all, in my recollection of the record. So that didn't come in even a little bit.
Okay, I'll look at that again.
Yeah, I would urge the court to look at that, and the record will show what it shows.
Okay, thank you.
I'm sure I'm getting close on time here.
Yeah,
so.
you're out of time. But I'll give you your rebuttal.
Thank you, Judge.
Okay, Mr. Schneider. You're muted.
Yes.
Okay.
Thank you, Your Honor. May it please the court.
Mm-hmm.
First of all, the district court correctly found as a preliminary matter that the petition for relief in this case that the movement filed was outside the 1-year statute of limitations in 60-1507 subsection F, and that for that reason, it wasn't properly before the court. And so
Mr. Schneider, let me just interrupt real quick. But
Yeah,
didn't
sure.
the court go on to say that that manifest injustice had been found because there was no way that he could have filed before then, which is just, you only have to show one of the exceptions under Vontris, right?
Right, and that's why the court found that we should proceed, or it should proceed with the on debate the newly discovered evidence based on Mr. Williams' affidavit, because that was something that couldn't have been addressed
Right.
at an earlier time. But the other issues that were raised were subject to the statute of limitations, because either, and again, the effectiveness of criminal trial counsel and appellate trial counsel were previously addressed by this court in the first 1507. So those were res judicata, and the other issues could have been either were or could have been addressed in the first 1507. So under the rules and the statute, they weren't properly before the court. However, Mr. Williams' affidavit was, and the court went on and then proceeded, and it conducted the pretrial hearing as the appellate courts have instructed district courts to do, and then proceeded to set the matter for a hearing or a trial on the newly discovered evidence. And then, so counsel couldn't have been ineffective for not arguing that, because the court, as a preliminary matter, found that those issues weren't properly before it. Now, Ms. Erickson couldn't have been ineffective because she could not, for not putting Mr. Williams on the stand, because ethically she could not have done so.
How is it ethically she could not have done so? She believed he was lying, but it wasn't something that her client, I mean, there was no indication that her client even knew he was going to be submitting this affidavit. I mean, maybe he did, but there was no indication. It came in separate and apart from the client. So it's not a situation where she has somebody that she knows for a fact is going to present perjured testimony. She has somebody that she has talked to, and she has drawn the conclusion that their affidavit is a lie, but she's got a client who's saying, put him on. If it's a lie, show it's a lie, but at least put him on. I do have trouble figuring out how she felt that was an ethical issue.
Well, because I think if we look at the record, she came to the court and said, I talked to Mr. Williams yesterday in the jail, because both Mr. Williams and Mr. Powell were brought back from DOC.
Right.
And at that point, they were in different prisons and different facilities, but they had been together at one point. It's when they were together that Mr. Williams created his affidavit, and Mr. Powell had a copy of that because that was the basis for his filing his pro se 1507 petition in this case. So he had that, and that's what we were proceeding. And then when Miss Erickson, they were both brought back, she went to the Wyandotte County Jail to visit with Kenton Williams, and he told her at that point, I will not testify as in my affidavit.
Well, we don't know that's what he said. We just know that she said that whatever he says, it's not going to help my client.
Correct. And she's in that ethical conundrum that defense counsel at times gets in, and not the first time I've seen it either, where they have an obligation to their client, obviously, and
she told her client, I don't think he's going to his
Right.
testimony is going to help you. And her client said, I don't care, put him on. If we got to figure out if he was lying then or if he's lying now.
But
Just put him on.
I'm sorry, but
She
if
she wouldn't be supporting perjury because she wouldn't necessarily be trying to lead him into perjured testimony. And there'd be a prosecutor that could cross-examine him.
but she also has an ethical obligation under, first of all, under Rule 3.1 of the rule of the disciplinary rules, the rules of professional conduct. She has to have a basis for asserting the issue. And if she doesn't believe she has a basis based on what she's been told by the witness, then I don't think she can ethically propound that. In addition, Rule 3.3 of the rules of professional conduct, she can't make a false statement or fail to correct a false statement or offer evidence that she knows to be false. And so if she knows that the evidence contained in the affidavit is false, then she's in this ethical trick bag if she presents it. She can't do that under Rule 3.3. And that's what was explored thoroughly on the record.
Judge Hill,
Counsel, I have a question for you. I started off by asking your opposing counsel about whether or not an appellate court evaluates situations concerning 1507 counsel, whether we have to come to the conclusion that relief would have been granted to this man, but for the ineffectiveness of counsel. And of course, she explained to me why she is pursuing the chronic standard versus the Strickland standard, although she maintains that she prevails under either. Would you please address that, your viewpoint on the chronic standard versus the Strickland, and whether we should, which one we should take into account?
Well, Judge, I don't think the chronic standard applies. The chronic standard applies as learned counsel so ably noted, when the counsel below does absolutely nothing for her client. And Miss Erickson certainly did way more than nothing for her client in representing him. Now, she didn't represent him the way he wanted, but that's a question of strategy. But to say chronic applies here, I think is not appropriate, because she actually worked for her client. She did something for her client. It didn't turn out the way either I think she or her client would have preferred it to turn out, but she did do something for her client. In fact, she did a lot for her client. Now, under Strickland, the court first has to find whether or not the attorney's representation fell below an objective standard of reasonableness. And an attorney seeking to comply with the Code of Professional Responsibility, I think it's hard, we would be hard pressed to say that her representation of Mr. Powell fell below that objective standard of reasonableness. You know, she proffered the affidavit. The court had that in front of it. It's part of the record, and the court refers to it in its ruling. But even if we were to say that it fell below, her representation fell below this objective standard of reasonableness that Chamberlain and Strickland set out.
Do you agree with Judge Standridge that the district court actually made a ruling on the merits?
I believe she did, because she says this isn't necessarily before us, but she went and made all of the findings that she needed to make to address it. And she says, okay, even if I believe this affidavit's true, let's assume that it's true, it still wouldn't change the outcome. And she cited the reasons why, because Mr. Williams' testimony throughout the 23 years of this case has been all over the place, quite frankly. But she also pointed out, as one of your colleagues noted, that there was other evidence of the defendant's guilt other than Mr. Williams' testimony. There were other witnesses to that effect.
Now, I don't want to take up all of your time, but I do want you to speak to what's the harm about just discharging her and appointing new counsel?
Well, and the court explored that. I mean, the harm is delay, and we were there for the hearing, so the court explored it. I mean, the court said, it was the first thing that came up, and the first thing the court addressed was Mr. Williams saying, "I want new counsel," and then he says, "No, I'm okay with Ms. Erickson." So that's the very first thing that was addressed, and then he changed his mind and said, "I'm okay with Ms. Erickson."
Counsel, if 11507 counsel has an ethical dilemma, would changing counsel change that ethical dilemma, or would not the new counsel have the same ethical dilemma?
I believe the new counsel would have the same ethical dilemma.
So appointment of new counsel would not resolve that issue.
No, it would not. It wouldn't result in a different outcome, and it wouldn't change the ethical quagmire.
Well, new counsel might have a different idea.
Maybe, but when the district court's sitting there making a determination as to whether or not new counsel should be appointed, the court looked at McGee and said, he has to show justifiable dissatisfaction with counsel. And you look at, according to McGee, you look at three things. Was there a conflict of interest? And there's nothing that shows there was a conflict of interest between Mr. Powell and Ms. Erickson. You have to show, or an irreconcilable conflict. And there wasn't really an irreconcilable conflict. There was a disagreement on strategy and what Ms. Erickson could do, but it wasn't irreconcilable. And in fact, after initially saying he wanted new counsel, he said, "No, I'm okay with Ms. Erickson." And the third thing to look at is whether there's a complete breakdown in communication between counsel and the defendant. And the record shows obvious there wasn't, because the two of them were communicating in court at the hearing on December 18th, 2018.
What about the Smith case? Your opponent relies upon the Smith case concerning both issues. What's your viewpoint on that?
Again, I think this is different, because I think we have a case here where counsel put forth a great deal of effort to assist her client. It just, in the end, the basis for the 1507, the newly discovered evidence, went away.
Thank you. That's all the questions I had, Chief.
Okay. We've about taken up all your time. You can take a couple minutes if you need to in conclusion, Mr. Schneider.
Well, very, very briefly, I would ask the court to affirm the decision of the district court. The district court correctly ruled on the 1507, and the district court did not err in denying the movement's motion for new counsel. So I would ask that the decision of the district court be affirmed. Thank you.
Ms. Carver-Allman, you have your rebuttal time and you're on mute.
Thank you.
There you go. Mhm.
May it please the court. So I want to point the court specifically to look at record 2, and it's right around page 17 through 20. And it's
record 2, you said?
Yes, record 2, basically page 17 to 20. And
okay.
This is where they're talking about whether they're going to put Mr. Williams on the stand or not. And you have Mr. Powell saying, "We were never together. I got this affidavit from a unit team leader, not from Mr. Williams." And, there wasn't a time for me to have coerced him. And the state is saying, no, they were together. And so there's some real conflicting evidence there that's going on that counsel didn't do anything with. And if she had put him on the stand, she could have said, so when were you guys together? Tell me about this supposed coercion that happened. She didn't do any of that. There were two real things at issue in this 1507. There was that affidavit, and there was how the affidavit played into the broader context of all the other things that went wrong in this case, which goes to materiality of the affidavit. And counsel did nothing on either of those things. And I think Rule 3.3, our ethical Rule 3.3, it allows counsel to refuse to present evidence that she reasonably believes is false. I don't think this was a reasonable belief here. And for that reason, at minimum, Mr. Powell should have been given new counsel. And I think that this case really needs to go back for a whole new hearing on his 1507 motion with counsel who will investigate. And it's kind of, either way you slice it, you kind of get back to the same thing. He needs a new hearing on this motion with counsel who will work and fight for him. And that is what we're asking the court to do today.
So basically, I guess his position would be that by putting this person on the stand, even if the person is shown to be lying or claims to be lying in the affidavit, it just really plays into the whole argument that this witness is not credible. He's all over the place. We don't know. Maybe he's lying in the affidavit. Maybe he's lying now. Maybe we don't. So that's the benefit to the defendant of putting that witness on.
Exactly. And I think another thing that the court can look at, and this is, well, it's not tangential, but in Mr. Powell's first 1507, one of the claims that he made was exactly what this affidavit said, which was that Kent Williams got a deal to testify against him. And the court dismissed that claim because they said he didn't have a record to support it. So,
yeah, but that was already decided, wasn't it?
It was already decided, but I think, he comes back with this newly discovered evidence that supports the very thing that he's been saying.
He was
all
trying.
along.
Yeah, Judge Standridge.
Well, I was just going to say that that was litigated at an evidentiary hearing, I think, in the former 1507, where actually the district attorney, Jerry Gorman, testified that he didn't get a deal.
I believe that's accurate.
Right.
Okay.
Yeah.
So is that res judicata on that issue?
Well, he didn't have any evidence. I think that's kind of the point of newly discovered evidence at this point. He was trying to challenge that then, and he didn't have any evidence to challenge it. And then this new thing comes up that he couldn't have had at that time. So I think that just
where this witness says, yes, I was given a deal.
Yeah, actually I was.
Or I was threatened.
To show the materiality in this case and kind of belies the judge's assertion that this just really wouldn't have made any difference at all. If the court has any other questions, I'd be happy to answer them. Otherwise, I think that concludes my comments.
Okay, thank you very much. Any other questions from the panel?
Okay,
we will take this matter under advisement and issue an opinion as soon as possible. Thanks.
Thank you, Your Honor.